Welcome everybody to today's webinar. I am your host, Joel Comerford. It is an absolute pleasure to have you all here with us today. Today's topic is understanding business contracts, key legal terms every entrepreneur should know. So very, very important topic, especially now that the end of financial year is over. It's been absolutely hectic. I do hope everyone isn't too burnt out by it. I know a lot of people who are attending today's webinar are attending from a holiday break, so please enjoy those pina coladas and that sunlight on us. Now, who is going to be our guest speaker today? This will be my dear friend Sahil. If you've used Lawpath recently, then there's a good chance you've already spoken to him. We are excited to have Sahil here once again, one of our expert lawyers on our legal advice team. So Sahil's worked with hundreds of Australian startups and small businesses, especially at the launch and growth stages, which is perfect for today. From tech startups to tradies, cafes to consultants, Sahil has helped businesses across a wide range of industries, including, again, tech, trades, hospitality, retail, professional services, and NDIS. His approach is always practical, whether it's setting up the right structure, reviewing contracts, drafting terms and policies, or managing legal risks. Sahil is he's focused, sorry, on giving clear commercial advice that helps businesses move forward, not slow them down. So we're very, very lucky to have Sahil joining us today. Um, Also, a lot of our clientele jumping in today are also NDIS related too. So, look, guys, we do try to obviously focus on the topic at hand, which is within the slides. However, if you do have some other legal related questions, please by all means throw them in throughout. Sahil, we obviously have the Q&A at the end, but we have been inviting questions throughout as well. So if it's not going to ruin your flow, we will just go ahead and have you answer some of those too. So if you guys do have some legal related questions. If it is within Sahil's power to answer them, then certainly go for it and we will get through that. Now, if anyone here is new and you've never participated in one of these webinars, fear not. I will upload each PDF to an email with a bit of a breakdown of today's session and I will send it out to you all afterwards. And if you come in late or if you have to leave a bit earlier, we will upload every webinar to our YouTube channel. So if you just type in Lawpath on YouTube, you will see it there. Now, what will we be covering today? So, this session is focusing on helping you understand the confidentially understand and confidentially navigate business structures. And Sahil will essentially break down the key legal terms every entrepreneur needs to know and understand in regards to service agreements, supplier contracts, and client arrangements. What to look out for in common clauses like termination rights, payment terms, limitation of liability, IP ownership, and indemnities. Red flags to watch out for when entering new agreements, how to customize templates so they work for your specific business, tips for negotiating contracts that are fair, clear, and enforceable, and how Lawpath's legal plans can assist you guys moving forward with review and management of contracts, which is something I will touch on later on. Why does this topic matter? Contracts are the backbone of your business. They protect your revenue, define your relationships, and reduce the risk of disputes. But if you don't fully understand what's in them or rely too heavily on generic templates without guidance, you could be exposed to unnecessary risk. This is what we're dealing with every day with people calling in or pre-existing clients. So in today's webinar, it is designed to help you take control, understand the legal language, and make sure every contract you sign actually supports your business, not holds it back. So, without further ado, Sahil, if you would like to go ahead and take it away.
Thanks, Joel. Thanks, everyone. Hi, everyone. Good to see you.
Not sure if I can hear you. Apologies.
That's okay. Um, can anyone in the chat tell me if you can hear
No,
me?
nothing at the moment.
Just give me 1 second.
Nothing. Oh dear.
It looks like Joel, they can hear me. So
Mm,
I'm just gonna keep going. And
sorry, ladies and gentlemen. Just
he
one moment.
also.
We're going to figure. I had a client who participated in one of our webinars recently, and she actually liked that we had technical issues because it showed this wasn't a pre-recording. So, um, one moment, Sahil, we'll just figure this out.
Yep. It looks like everyone should be able to hear me according to the chat. So I'll keep going, and then Joel, when you can hear me, just scroll down. So we might just skip on the slides for a little bit until Joel can hear me. Okay, I'm just going to get into it. Contracts. Seems like contracts do a lot more than just record a deal, right? They actually set the expectations from both sides. So first, they protect your interests. A good contract will clearly say who's doing what, when, and how. That actually avoids a lot of the he said, she said down the track. Contracts also reduce risk. So a vague or a rushed agreement can lead to misunderstandings, and obviously that can get expensive, especially if it ends up in dispute. Um, Going on from there. And lastly, knowing what's in your contract lets you negotiate with confidence. So you're more likely to push back on unfair terms if you actually understand them. So we're going to go to slide 6. Hopefully, Joe will move on to slide 6. So to be legally binding, a contract needs a few key elements. So let's walk through them now. Offer and acceptance. So first is offer and there's acceptance. So one party makes a clear offer, like we'll supply this service for X number of dollars, and the other accepts it. So it seems simple enough, but it's actually worth checking that the right entity is named in the contract. Often we'll see like somebody might have a company, but they've put their personal name down, and you really don't want to end up signing a contract with the wrong person or the wrong company or the wrong entity. We'll go to the next slide, please. Then you've got consideration. That's something of value being exchanged. So think money, think services, think IP. It doesn't have to be cash, right? So and the most important, one of the final ones is a clear intention to create a legal relationship. This one is actually often missed, especially when people either shake hands or they say that, you know what, we'll sort the details out later. That might not hold up if something goes wrong. We'll go to the next slide. And now we're getting into the core of the session. So the key legal terms. The key legal terms you want to be aware of when reading or signing contracts. So the first one is indemnities. So indemnities can be one of the riskiest parts of a contract and often the most overlooked. An indemnity is a contractual promise where one party agrees to compensate the other for specific losses, liabilities, or damages that may arise. It is a complicated one. A lot of my clients are often very confused by what actually an indemnity involved, but essentially it's a financial safety net for the other party. It's a promise to cover someone else's losses. The classic example, but I'll give a better example in a bit, but basically party A indemnifies party B for any claims related to the use of software. But here's the catch. If the clause is too broad, you could be responsible for things even if they weren't necessarily your fault. So I'm going to give you an example. Let's say you're a marketing consultant. You've built a campaign for a client. Your client posts an ad based on your content, and later that client gets sued for using a photo that turns out to be actually copyrighted, even though they are the ones that uploaded an image. It wasn't part of your deliverables. Now, if the contract is really broad, so if it says something like you indemnify them for any third-party claims arising from the campaign, as you can see, that's really broad, you could be actually footing the legal bill yourself. And we'll go to the next slide, please. So here's what to watch for. Scope. Does it include just direct losses? Are there indirect losses included, like lost profits, maybe? Cap, is there a maximum liability amount? Or could you be liable for an unlimited amount? Duration, does it apply forever? Does the indemnity apply forever, even after the contract ends? Would that make sense for you or for the other party? And mutuality. So is the other party offering you the same protection? Is it reciprocal? If there's no time limit or if there's no time frame, you could be taking on a lot of risk, especially if there's no amount limit. It's always worth asking, what actually triggers this? Can it be capped? And should it be mutual? But that's all on indemnities. We'll go to the next slide, please, Joel. And again, uh, warranties and representations. These terms often get bundled together, but they're actually a lot different. A warranty is a promise made in the contract. For example, you might warrant that a product works as intended. A representation, on the other hand, is usually made before the contract is signed. It's something that essentially convinces the other party to go ahead. We'll go to the next slide. So if you give a warranty for something that's outside of your control, let's say, for example, the results of a marketing campaign, you could be on the hook. So another example is if you say the software is warranted to be free from defects for 12 months. Again, that's something that could be potentially out of your control. You should also be careful about relying on what's actually said over email or phone. If it's not in the contract, it may not actually count. So you need to be really careful around that. A lot of people get caught out here. That's why we actually include an entire agreement clause. It's basically to make it clear that only what's written down in this contract counts and nothing else. We'll go to the next slide, please. Key termination clauses. Let's move on to the termination clauses, how you or the other party can actually exit the contract. And there's two common types. One is for cause. So let's say someone breaches the agreement. And secondly, it's for convenience. So that's where there's no actual reason required for termination. These clauses obviously affect your ability to walk away, right? So if the other party can leave very easily, but if you're locked in, that is a clear red flag that you need to address. Imagine a local IT consultant. This is actually somebody I worked with about 6 months ago. They were on a retainer agreement with a corporate client. Halfway through, the client actually terminated for convenience with just a 2 weeks notice. The consultant didn't actually have that same right. If he hypothetically wanted to walk away, he wouldn't be able to. And therefore, he was stuck turning down other work, and he was expecting that this income would come through, but the client ended up terminating for convenience. That leaves you in a really difficult situation, essentially. We'll go to the next slide. So keep an eye on some things. Notice periods. How much notice do you actually need to give, or how much notice do you get? Is it 30 days? Is it 7 days? Is it reasonable for what you need? Automatic renewals. So does the contract just roll over if you don't cancel in time? And post-termination obligation. So what do you actually have to do once the contract is ended? Do you have to return their data? Do you have to stop using their IP? Will that affect your business? Do you have to shut down access? You have to take all of this into consideration. And it's actually really good practice to set calendar reminders for key termination clauses or key termination dates, sorry, or renewal dates. You should definitely look out for these. We'll go to the next key term, confidentiality. So confidentiality clauses protect your sensitive information, as a lot of you would know. Things like pricing, your client lists, your source code, your financial data, things like recipes, even how your internal processes or operations work. But the value of these clauses depends on how they're actually written. How detailed are they in the contract? You should ask questions like, how long does it last? Is the NDA valid for a year? Is it valid for 5 years? Is it valid indefinitely after the termination of this contract? And how does this potentially impact you? You should check what's covered, especially what's the definition of confidential information in a contract like that. Is it just written information? Is it things that are said in meetings? Is it know-how? Is it concepts? What is covered? And are there exceptions? So what about if the information becomes public in another way? Is it still confidential? And a big piece of advice is, even before you get to a contract stage, if you're just discussing your business concept or just having a very, very, preliminary discussion, you should consider using a standalone NDA to protect your information in early discussions. We have a template for this at Lawpath as well, but it is really, really simple. It's really useful. It doesn't scare away your client, but it keeps your information confidential. We'll go to the next slide. The next slide, in terms of other legal terms to know. Yeah, perfect. Thank you. So there are a few other contract terms that pop up regularly, and they're definitely worth being familiar with, even though they might sit down near the bottom sometimes, others are a lot more important. So, for example, limitation of liability. Uh, this clause, it sets a cap on how much someone can be held responsible for if things go wrong. Let's say you write a script. No, sorry. Let's say if a script that you write accidentally deletes some of the client's files. Now, a limitation clause can cap your liability to, for example, the total fees that was paid to you. Let's say it might be $10,000. Without it, they could actually come after you for far more than what the project was worth. And so having a limitation of liability clause in is a really smart way to keep it proportionate. That's really important. A force majeure clause. So this is your safety net when things go completely off script. So think floods, bushfires, pandemics. During COVID, we know that a lot of small businesses obviously had to cancel contracts. Those with well-drafted force majeure clauses could actually pause or they could terminate their agreements without any penalties. But those without, as we know, many were still expected to either perform their services or provide a full refund. So that is really important. IP clauses, I've given webinars on just IP alone earlier, so it's obviously very important. These define who owns what when intellectual property is created or is shared. So, we work with a lot of startup founders, and one in particular hired a freelance developer, as a lot do. They didn't actually realize that the default position was that the developer actually owned the code unless the contract said otherwise. We know that in Australia, if you create something, you own it. And if there's no contract in place, or if the contract doesn't clearly say that, the person that was hiring the developer will own all the IP in exchange for paying for it, it's not necessarily guaranteed, right? So that meant that they couldn't actually freely build on it later on as well. And a simple IP clause likely would have sold that from day one. So yeah, it's really, really important. Make sure you definitely take it into account. Dispute resolution. This sets out how you handle disagreements, obviously. So will it go to court straight away, or will you try mediation first? And, up front, it may not seem that important, but when things go sideways, this clause actually saves you potentially thousands of dollars. And then also governing law. So this tells you which country or state's laws apply. If you're working, let's say, with somebody in the US, let's say you're working with a US brand licensing your product, but the contract says that Australian law applies, that's actually really, really helpful for you. It means that any legal disputes that happen under the laws that you are familiar with in Australia, rather than dealing with it in a foreign jurisdiction or foreign rules that you've never, ever dealt with. So these are some other key legal terms, and we'll go to the next slide. And how to spot risky clauses. So what should you be looking out for? Here are some of the big red flags. We've gone through a bunch of them already, but essentially uncapped indemnities. So what does that mean? Essentially, if there's no limit, there's a lot of risk. You could be liable for unlimited losses, even if it's someone else's mistake. Again, you should check if there is a financial cap. Is there a time limit? Second is automatic renewals that you can't exit. So there's a lot of contracts out there that may auto renew unless canceled within a short notice period. Think a lot of subscriptions that might be out there. You should always check renewal terms and cancellation processes or termination processes. One-sided termination rights. So again, as I discussed earlier, only one party can terminate the deal easily, potentially leaving you stuck. You should check whether termination rights are fair and mutual. And then ambiguous language. So there's a lot of vague phrases out there like reasonable effort, which sometimes work, but sometimes create legal gray areas. So you should definitely check whether these terms are clearly defined and are they measurable. We'll go to the next slide. Common mistakes to avoid. So here are 3 common mistakes that are actually quite easy to avoid. So not reviewing key terms clearly, especially indemnities, payment terms, and termination rights. Many founders, it can be tempting to skip straight to the signature. That's risky. You need to be careful. Failing to negotiate unfair clauses. Just because it's in writing doesn't mean it's set in stone. You should definitely consider pushing back on terms that are one-sided or unclear, and you should most definitely consider negotiating any contracts that you receive, where even if you feel like there may be, no potential reasonable scope to negotiate, you should still consider it. And thirdly, ignoring obligations that trigger after the contract ends. So there's some duties, especially confidentiality or indemnities or even final payments that survive termination, even if the contract has actually ended. You should really check what carries over, and you can't assume that everything ends at cancellation. Um, so this is a great question. When should you do it yourself versus when should you get legal help? And so let's get into this because it's obviously really relevant to us here at Lawpath, where we have templates available for you to use, but we also have lawyer services, legal services available. So you don't need a lawyer for every single contract, but it does help to know when to get help, right? DIY works well and definitely might work if it's for example, a simple NDA, if it's maybe a low risk supplier deal, or if it's a template you've used before and fully understand. I know a lot of my clients use our employment agreements all the time because they are quite straightforward, but they're comfortable with the content that's in there and they get it checked by myself or another lawyer on our legal advice plan. But on the flip side, you should get legal advice if it's a high value deal. I often like to say maybe above 20, 30K starts to get really high value. You should definitely consider talking to a lawyer, get legal advice. If there's any sort of equity or IP involved, maybe where it gets a bit more complex, where there's software involved, where there's a lot of IP involved, you should definitely consider it. And just generally when terms are complex or if you're unsure, and then also if the contracts are cross-border or if you have, let's say, an app or a marketplace or a website or something, a business that applies more than just in Australia, 100% you should seek some legal advice. And one strategy I generally recommend is if, like, for example, if you've received a contract, is to review it yourself first, flag the bits that you are unsure about first, and run them past a lawyer. That might keep your costs a bit more efficient, a bit more cost effective. Really depends circumstance to circumstance. I'll go to the next slide. Yeah, next slide again, sorry. Final takeaways. So this will be kind of my final thoughts, but essentially to wrap up, and Joel, you can go next slide. Don't skip over clauses. If it sounds confusing, it probably needs a second look. Watch out for red flags. So again, broad indemnities and unfair termination clauses. These are some of the more complex clauses in the contract. So you should definitely double check yourself first and then double check with a lawyer. We know that small mistakes can cost thousands, so you'd rather be careful. Think about the full extent of the contract, even if it's over multiple years, what would happen at the end if somebody tried to exit. Be detailed in your review. Even small things can be overlooked, and you need to be careful. And then finally, you don't need to be a lawyer, but definitely know when to call one, especially when the cost is minute compared to the actual transaction and the potential losses. A good contract basically should protect both sides, but it should make you feel a bit more confident doing business and not more confused. So don't let it rattle you. And yeah, that's pretty much it from me. I will pass on to Joel to maybe talk about how Lawpath would be able to help. Cool.
Thank you so much, Sahil. Before you go, if I may, and apologies for the technical issues earlier, everybody. So what I find a lot of the time when I'm communicating with clients is they'll come by and everyone knows we have the free document that they can get their hands on. And if they need something else, they can obviously come back. I'm finding a lot of clients are, very headstrong. I'm fine. Obviously, contractual law is super complex when, as you mentioned, it's like a lower tier employee agreement, for example. But I'd say a good 60 to 70% will always come back if it is that higher tier, as you mentioned. And they said, you know what, there are some gray areas within the document. I am kind of concerned. Maybe I should speak to a lawyer. So, very broad question. I do apologize for putting you on the spot, but around this time, end of financial year, a lot of people are registering more companies. Um, what's the largest, I guess, if we could categorize it, what's usually the biggest issue that you're finding around this time, especially around people registering business for the first time, which obviously legal advice can assist with?
Yeah, absolutely. And to be fair, as easy it is to register a company in Australia, there's still a lot of technical questions out there. I definitely even recommend talking to firstly our company's team or our lawyers when you are registering a company, for example, understanding what is a director, what the director duties and obligations are. I've had many consultations just to discuss what a director can be on the hook for example, potentially for somebody just starting out their business. What are shareholders? How many shares should you assign to yourself just starting out the company? A lot of people do one share where maybe they should be starting out with 1,000 shares. So there's a lot of different things that go into it. It's not as super straightforward, although I think going through that questionnaires and going through potentially legal help can resolve all of that pretty quickly. And then just generally at the early launch stage, we're talking to a lot of people about contracts in the sense of whether it's service agreements, if you're doing, let's say, B2B or direct one-on-one clients, or if it's terms and conditions, whether it's a platform, whether it's a marketplace, whatever it might be. But those are basically the cornerstone documents of your whole business. And essentially, any potential liability or risk that you may face will be governed by either those terms and conditions or those service agreements. So most definitely those are the ones that need to be worked on the most. I think for a relatively low transaction, the templates are a really, really good starting place, but they are templates, right? At the end of the day. So sometimes you might need more legal help for some complex matters. Other times you may coast through with just the templates and be really comfortable that that will protect you. Yeah.
Thank you so much. Much appreciated. And guys, if you guys have questions, please throw them in the chat box there. We will jump over to those in a moment. So, how can Lawpath assist you guys moving forward? Essentially, you probably already know this, everyone, but if anyone's new, uh, you're an entrepreneur, you're a new business. How much time do you have to quickly leave the office and go and speak to your lawyer or go and see an accountant? At times, it might not always be as accessible, or if you have an issue that you need to have corrected immediately, but you have to wait 3 or 4 days to get in with someone, it's not necessarily the case with Lawpath. We've designed our system to be on stand, ready to go whenever you need it. Now, if you do use our legal advice or accounting advice, you will naturally get a single lawyer or an accountant that you prefer, and you will always have time to speak with them. But if it's a last minute scary issue, ASIC related, and perhaps a contractual issue, then you can go ahead and book a consultation with someone else on the spot. And that's something we certainly provide. If you wanted to have an unlimited supply of our documents, so 550 plus, as you could see, all templated, all updated, usually within 6 months or so, whenever the legislation tends to change, then you can get that through us. You have unlimited edits with all of our documents. There's no Lawpath watermark, so you can put your symbol up the top there. Each document comes with the e-sign feature as well, which is really helpful if you are starting out and you're trying to appear more professional with clients, or if some of your clients are out of state, for example, or elsewhere. And then when you do reach that stage where, okay, I am creating my own contracts, this is great, this is helpful, but I don't understand this section, and this section, and is what I've put in there actually contradicting this? That's when you can hop on a call with Sahil and his other and his team members and get that kind of support that you need for your business. So that's essentially the accounting and legal. And when it comes to, sorry, that's essentially the legal. But when it comes to the accounting side as well, it's the same thing. You're starting off a new business. You don't necessarily, because you're not making all that much money, you don't really need to be paying a bookkeeper to be doing all this work that you could essentially be doing yourself. So we've over here at Lawpath, we've partnered with people like MYOB and Zero. And if you are using a free account, or if you have a subscription with us, if you go on the left-hand corner of your homepage, you'll see partner offers. These offers will always be available for you, and you can claim these whenever. They're not going to disintegrate and disappear after a certain period of time. So the goal is to to get you comfortable with doing your own accounting, your own bookkeeping, your own payroll, your own invoicing, and just having an accountant, much like the lawyer, review what you're doing to make sure that everything's accurate. And then when you want to have those deeper conversations or conversations around business structuring, how best to invest in things in the future, how much tax should I be withholding for certain items, do I have the budget to hire my first employee, whatever it is, we have those deeper conversations with you with those plans as well. Two options for our plans. You've got annual or you've got quarterly. We have a cheaper versions for our annual options. It's just easier to pay outright. You get your invoice straight away. It's tax deductible through all of our plans, and you will have instant access to create a profile, meet a lawyer and accountant that you prefer from our team. You get to have that preference, and then they will train you, teach you, give you that autonomy to run your own business comfortably, whether the 12 months is up or you want to keep evolving with us, so to speak.